Good morning, dear students. We already discussed about defamation and the second part of defamation in Indo. So now we are going to discuss cyber defamation or online defamation. So with the advent of the internet or technology, so it has become easy for everybody to express their ideas or opinion through social media or the media network. So many things are there. So it is a part of healthy democracy. We have to agree. At the same time, so some people, they wanted to defame the others by their speeches or writings over the net or their speeches over the net. So it has become defamation and it is called cyber or online defamation. So please remember, online defamation means nothing but the defamatory things, maybe oral, maybe slander, maybe libel, carried on through the medium of internet. That's all. Or they carried on through the computer resource like computer, laptop, hard disk, all this. So if anything is done through by using the so-called computers, if any defamation is done by using the computers, it is called online defamation. So at the outset, I want to tell you that there is no straight cut section for cyber defamation. Straight away, there is no section. Previously, the people used to apply section 66A of the Information Technology Act 2000, which says if anybody sends any offensive, grossly offensive or menacing character with the intent to cause injury, so many assault, injury, defamation, all these things, it will be dealt with under section 66A of the Information Technology Act. But with the judgment, very famous judgment of Shreya Singhal versus Union of India 2014, wherein Justice Alameshwar and Rohinton Nariman, they held that this section is unconstitutional because to express opinion is the fundamental right. So dissent is the decency of the so-called democracy. In democracy, there should be dissidence. So definitely there should be somebody to condemn your attitude. Otherwise, you will go on straight line and you will get some wall hit, and then only you will realize the ground reality. So therefore, section 66A is held unconstitutional. At the same time, please remember, this section is not removed from the Information Technology Act. It was declared as unconstitutional. Maybe tomorrow some judgment may come that 66A should survive, it will be there. It may come. So at present, 66A, you cannot use them, right? So now how to take action? Definitely, so you have got the Indian Penal Code provision, section 499, 500, and coupled with the Information Technology, section 67, 68, so many sections are there. Anyway, so if the defamation, the act of defamation, may be libel, may be slander, if it is done through the so-called electronic media or the computer resource, it is called online defamation, right? So, section already, now because of the widespread use of the internet, definitely it is taking a new face and not controllable. Literally to speak, not controllable. Now we'll discuss some case laws. So very famous case law, State of Tamil Nadu versus Subhash Katti, 2004. It is the first Information Technology Act case, very famous case. A woman who lost her husband, who became a widow. In her name, some email account has been created by the Subhash Katti fellow, and he has been soliciting the persons, and people used to give messages to her. Ultimately, a stage has come where they used to come to her house and knock the door. Actually, as a lady, as a woman, she felt embarrassed even to report to the police. Ultimately, since she knew a DCP cadre officer in Chennai city, so the matter was taken to his knowledge, and then they have actually ethical hacking was done through the computer resource, and ultimately this man Subhash Katti was traced in Bombay. He was arrested, and it is the first case where a conviction has come. He was convicted for 2 years. So it's nothing but defamation, is it not? In the second case, Shreya Singhal versus Union of India 2014. What happened is actually two school-going girls, one is 10th class and another is 9th class, I believe. So both of them, actually they passed certain remarks in the Facebook or some social media. It was on the occasion of the demise of Sri Bal Thackeray, who was Shiv Sena leader. So the Shiv Sena cadre, the government, they wanted to give 2 days leave for mourning over the death of Bal Thackeray. So their work has been hampered. They could not go to the schools. Her father, one of the students' father, he could not go to the bank and get the money. So therefore, they actually, one girl, she has posted a comment. So if the believers or the followers of Bal Thackeray are so much interested in him, so let them go to his cemetery and pray for 1 day or 2 days, whatever. Why should they disturb the public life? Why should the public life come to a standstill? This is the comment by her, and it was ticked or forwarded by other students. Both of them were arrested by the government. They were kept in jail, and a public spirited intellectual advocate by name Shreya Singhal, she has taken the matter before the Supreme Court. Ultimately, Supreme Court judges bench held that it is unconstitutional. Such is the gravity and most important case. And another case is the SMT Pneumatics versus Quatra, I think. SMT Pneumatics Limited versus Jogesh Quatra, 2014. Actually, Jogesh Quatra was an employee in that SMC Pneumatics. He was doing some mischief. They warned him. He did not care. He was giving useless mails to some persons. Warned him. They removed him from his job. Then, annoyed by this, so he started sending useless defamatory messages to the fellow employees in the company and also to the traders. So with the intention to defame SMC Pneumatics. So ultimately this was held to be defamation and is given. Actually at the outset an injunction order was given and he was asked not to give any such messages. But he did not stop. Ultimately he was convicted. So there is another case. Ramdev Baba case, Swami Ramdev and another versus Facebook INC and others 2019. Right. So normally, some people, Baba Ramdev, he has become neo-rich or suddenly, so whatever, it is a different thing. But against him, some tollings have come. That he has been using the so-called political power, that his ashram is being something like that, so Ayurveda, so it is also not up to the mark. So many things have been written. Defaming his so-called Patanjali products, they were being reported in the Facebook. So Facebook, the government asked the Facebook to remove them, but at the outset they did not agree, and therefore Swami Ramdev Baba, he has filed a defamation case against Facebook and others. So Justice Pratibha Singh, she ordered to remove the defamatory content against Baba Ramdev, which has been uploaded from computer resource, different ways of Facebook. Anyway, so Facebook has argued that the statement of opinion, they are not statements of fact. Therefore, they are not defamatory. So if somebody writes in his blog that John Smith hit his wife 2 weeks ago, it can't be defamation. Of course, the court did not agree. First of all, you remove them and then you speak to us. It was done. Anyway, this is also another good case. These are the cases of online defamation. Remember them. You may get a small question, I believe. But if it is otherwise, it will be for your academic interest only. Thank you.